In the Indian legal context, the word repugnant indicates a conflict or a contradiction or an inconsistency between two laws or two provisions. The word repugnant is also used in Article 254 of the Indian Constitution, from where this doctrine or principle of repugnancy actually comes from. This article says that if there is a contradiction or a conflict between a law made by the state legislature and a law made by the parliament, this is a situation of repugnancy. In such a situation, the law made by the parliament will supersede or prevail over the state law, up to the extent of the repugnancy. If only a part of the laws or some provisions are repugnant, then the central law will override the state law only to the extent of those repugnant parts. But if there is a complete repugnancy between the two laws, that is, there is a complete contradiction or a complete conflict, then the central law will fully override the state law. There is also an exception given in clause 2 of the article, which says that the state law can prevail over the central law on the concurrent list subject if it has been reserved for consideration and receives the assent of the President. This exception again has another exception, that even if the state law has prevailed over the central law thanks to a presidential assent, it does not prevent the Parliament from passing another law on the same subject that adds to, amends, varies, or completely repeals the state law. The principle of repugnancy was confirmed by the Supreme Court in the M. Karunanidhi versus Union of India case, where it held that if the provisions of a central act and a state act on a concurrent list subject are fully inconsistent and absolutely irreconcilable, then the central act will prevail and the state act will become void in view of the repugnancy.